strategies for marketing in particular evolve and progress, there's always something new that I'm going to have to account for, and there's something new that I'll have to write,
That makes sense.
when things progress, yeah.
That makes sense. Well, good morning. We are on another episode of the Avocado Toast, One with Gratitude, with Robert Freund, because this is our second time trying this. And I'm a little embarrassed to say the first time we had some audio issues, and Robert was gracious enough to come back and have another conversation with us. So thank you so much, Robert. Good to see you.
Yeah, thanks for having me.
Yeah. So let's see here. Can you introduce yourself? So Robert Freund from Freund Law, I believe.
Yeah, Robert Freund Law is the name of my firm. I'm an advertising and e-commerce attorney. So what I focus on is helping consumer brands and marketing agencies comply with the various federal and state laws that apply to selling things on the internet. So FTC compliance, state consumer protection laws, those are the things that I think about helping clients comply with and help them avoid, or hopefully avoid, ending up in the kind of litigation that I used to handle during the first part of my career. So for the first 7 years from graduating law school, or almost 7 years, I was a commercial litigator at Greenberg Traurig here in LA.
One of the biggest firms in the country.
One of the biggest firms. I think they were number one in the world by offices. I don't know if that's an important metric, but they used to boast that they had more offices than anybody. Classic like big law firm with everything that comes with that. And a lot of what I was doing in the litigation department was defending consumer class actions. And a lot of those had to do with false advertising issues. And those issues and those types of advertising claims were the most interesting to me, like intellectually and professionally, than the other types of litigating I was doing. So when I decided that staying at a large law firm was not for me, and I decided I would start my own practice and give that a try, I knew I wanted to focus on like advertising law and e-commerce issues primarily, and eventually get out of litigating. And now I started the firm in 2019, so I guess that's like 5.5 years. And so now I very rarely will litigate anymore, and I accomplished the goal of just focusing on the sort of advertising law issues.
I see. You advise clients.
Yeah, most of it is like advice and counsel and drafting related agreements. So if it's a brand hiring an agency or vice versa, or you're working with influencers or doing any kind of affiliate stuff, having litigated breaches of those contracts and the issues surrounding it, I feel like I feel like having a litigation background is an advantage if you get into the world of transactional work and drafting.
Yeah. Well, Robert's actually being a little bit humble here. I mean, that is what I believe what your practice does, but I think some of you may know Rob from the internet. He is, I don't know how to classify it in this modern age, but I mean, he is one of the bigger voices out there in the law on Twitter and on Instagram and even traditional media these days.
Yeah, I mean, I do all of my marketing on social media. I started on Instagram. I'm there less now as compared to Twitter. I'm going to be venturing into YouTube here in the near future, and it's worked great for a number of reasons, and there's a number of really good benefits of it, not the least of which is that it's free, except for the time it takes to create content. So I don't have to spend on marketing or anything like that. I sort of repackage or digest issues that I'm thinking about for clients anyway, and then make them understandable, which is what I have to do in the job. And then so like a lot of it's almost not like it's separate from work. It's like, well, I just spent X amount of time looking over this new issue or thinking about this case that's made the news, and other people find it interesting, and then it gets shared around, and that has generated like 90% of the business for the firm. So yeah, social media has been a great tool for me, and it's rewarding to see people react positively to stuff you put out there.
I bet. I mean, that's actually how we met, right?
Yeah.
I was just browsing through Twitter, and Rob shared a really interesting snippet from a complaint, and I looked him up. I saw it on the website, and I found out that we went to the same law school. So, as a person who sometimes lacks in shame, I just cold emailed him right away. It's like, hey, my name is Peng. Can you share this with me? And Rob was gracious and shared the entire document with me, so I was able to help me directly with my work. And then we started talking, and I was like, please come on the podcast. And so hopefully our audience can get to meet Rob, and if nothing else, hopefully establish a professional friendship of some sort.
Yeah, I mean, it's great for that too, like the networking benefit. All of the lawyers that I've actually that have either reached out to me or the other way around that I met through social media have been not only really good attorneys, but personable and people that I like more so than you go to in-person mixers and stuff, and it's going to be a mixed bag, and I'm not the kind of person that really likes in-person schmoozing so much. Of course there's a benefit to it, and I do it, but I don't get excited about it like some people do. It's much nicer for me personally to just be at my computer and put stuff out there and meet people that way, and then meet them in person and do things that way. So it's definitely, there's a huge networking opportunity through social media also.
Yeah, I think the people that gets really excited about in-person mixers are more excited about drinking.
Probably.
Yeah.
And I mean, some people just have the gift, they're just really good, charming, very charismatic people that just do well working rooms, and they like going to conferences and meetings and stuff. And I'm jealous of that in some ways. I'm sure business would be even more booming if I was just constantly hitting the mixer circuit and doing all that, but that's just not my personality. So it's nice that there's an alternative for people like me.
Yeah. Well, do you want business to be more booming? You're busy as hell, right?
I mean, I'm comfortable with how busy it is, and I feel like probably every business owner, and whether it's a law firm or not, there's the tension between am I comfortable, assuming you have enough business, enough meaning whatever metrics you set for yourself for being satisfied, how much more do I want to hit the gas pedal and try to grow with everything that comes with that, more stress and more complexity versus, is this comfortable? Am I being too comfortable? And I always go back and forth with that. Maybe I should try to double the amount of clients I have and then hire people and build out all these systems. And some days that seems like the move. And then some days I'll be like, you know what, I've got enough work to do. I really enjoy having weekends mostly free, and maybe I'll just raise my rates instead of trying to build. So yeah, I go back and forth with that.
Well, so me and Rob, we have a bit of a similar background. Although I was mostly in plaintiff's work the majority of my career, I spent a few years in big law also, so I have a pretty good understanding of both sides. But as business owners, both of us, and that's really where at least the draw for me, right, is the management of my own time, the agency, right? My girlfriend will attest that I work more now than I did when I was in big law, which a lot of people find surprising, but I have a natural talent of slacking off,
right? Which
I can't really do when you're your own boss, because you're just lying to yourself. But it's how do you weigh the decision between, because you've been doing this for 5.5 years, right? You have the capabilities of growing. It's not like you can't find more clients.
Yeah.
So how do you weigh the pros and cons of growing and hiring and expanding versus staying where you're comfortable?
Yeah, I mean, it's difficult to do, and I'm not always sure that I'm making the right choice with that. But I'll talk to friends of mine who are in that high growth mode and opening more offices And on the one hand, they are making more money than me. That is true. But on the other hand, every time I talk with them, the first thing they'll complain about is how like I haven't slept in a week, and I've been working all weekend on this, and I'll think that sounds awfully close to why I left Big Law. and I mean, maybe I will get the feeling at some point that I must have more money coming in, and like I need to do that. But I don't feel like that would really be the only reason for me to do it. It's not like I feel like I need to prove anything by like running a huge office or something. And right now I'm comfortable with how much is being made, and I don't feel the urge to grow in that way. I'm much more interested right now in seeing what's possible on YouTube, to be honest, because I've seen lawyers who I know I know at least one personally who has made so much more money as a result of YouTube, such that they don't even really have to practice now because of what they built on social media. And while I really enjoy my practice, if the choice were between you can make X amount of money doing legal work for most of your waking hours, or you can make the same amount of money putting out educational YouTube videos and working on social media stuff, I would choose option 2 because that's much more appealing to me. So I feel like right now where I'm at, I want to see what can happen on YouTube in a couple years of consistency. And if I feel like this is not going how I thought it might, and I also feel like I need to have more money, then maybe growth of the firm at that point will make more sense. That's sort of how I'm thinking about it right now.
Yeah, that makes sense. I mean, from the books I read and from the people I talk to, it always seems like this desire and drive to grow bigger comes from something within, right? It's not an external need, because you can
absolutely, yeah. And I feel like, to your point about working more as a business owner versus at a firm, it doesn't feel like work per se when I'm doing stuff that's for the benefit of my own practice, because it's like for me. And I was thinking about that maybe last Saturday or something. I spent a couple hours just like getting up to speed on like Lexis alerts that I get for cases that are interesting, and reading through developments and putting out Twitter stuff. And it took me maybe 2 or 3 hours. And I was thinking, like, if I were still at a firm and some partner told me to do that on a Saturday morning, for sure that would feel like I just worked for 3 hours on Saturday. It doesn't feel like, oh, I'm on the clock working. It's like, well, of course this is what I do, because like it's just much more rewarding and fulfilling, and feels like I'm helping myself rather than doing what I'm told, if that makes sense.
Yeah, exactly. Absolutely. I would equate it to going to the gym, right?
It is like that, yeah.
Yeah, like when you're somebody that, I mean, from one look at you, you look like somebody that goes, I'm going to wager a guess you go to the gym.
Yeah.
Okay. Right, like, I think like, I don't know when you started going, but I remember when I was a kid, going to a weightlifting class, right? The same thing as what you're describing with work. I don't want to go. Yeah. I'm sitting there, I'm pretending to lift weights, like I'm bench pressing just the bar, and it's just, I don't want to do it. Versus now, I plan my whole day around.
Same.
Right? Like I'm trying to, I'm researching different supplements, like I'm reading online, trying to decipher the bro science from the real science.
Yeah. Absolutely. Yeah, and it's less of like, this is what I have to do, and more just like, well, this is what I do. Like, of course I'm doing this.
This is who I am now.
Yeah.
Although I am going to expand on that point. I agree with you 100% that it doesn't feel as much like work. It's just what you do. But some of the tasks feel a little bit more like work.
Yeah, I mean, like getting bills out. I haven't hired someone to do that, even though, I mean, I guess it would save me a couple hours a month if I had somebody just do that, or like do all my accounting. I mean, in terms of like trust accounting and stuff. Yeah, I have an accountant and I have a bookkeeper, and that's definitely worth it. But yeah, all the admin stuff, that sucks. I certainly don't enjoy, entering all my time and all of that, but it still is not as bad as like it felt entering my time at the end of the month at a firm, because I get to see like,
end of the month.
Right.
See, and you're not supposed to do that.
Well, I mean, like the reality at like a big law firm is most associates are doing it either at the end of the week if they're on top of their shit, or like it's at the end of the month. And,
but you get daily emails reminding you to do it daily.
Yeah. But those emails come from partners who I know have their assistants just like try to figure it out from their emails.
Yeah, they literally have a biller.
Yeah. Today, like I do it all like contemporaneously. Like when I'm done with something, I will write it there. And it's because in Clio, my practice management software, I will see like when I type in how much time, there's a dollar number that gets pumped out, and that feels good. And that feels better than being an associate where it's like, all right, I know like this is precisely how much I'm going to make this year, notwithstanding a bonus that I probably won't get. It's way more motivating to be like, all right, I just spent an hour. That means this amount for that day. And then, you set goals for what you want to do on a per week basis. And then it doesn't feel like a pain in the ass to do your time. It feels more like how well did I do today,
Yeah. It's, again, drawing back to the gym, it's like you're trying to hit a new PR, right? And you're trying to work on your form, right? It's not because you want to do this and you're doing it for yourself.
Or if you keep a log, like I don't want to try to remember at the end of the month what my bench was. Like I want to know right now and compare it and see like, all right, I did hit 10 on that weight this week or whatever it is.
Exactly. Yeah. I was always, I used to be a horrific biller, right? End of the month, like multiple conversations with partners, it's like and that's, to be honest, that's one of the reasons I started my career out in plaintiff side, so I can block bill.
Yep.
And then during my time in big law, oh my gosh, is brutal, right? But now I am phenomenal. Like I do it contemporaneously. I start the timer.
Yep.
I mean, given that I'm back in plaintiff's litigation, I could, I don't have to do it every 6 minutes. Mm-hmm. But I am very on top of it because, like you said, that I see how much money is going to come in from that, and that's very important to me. And to tell you, elaborate a little bit on this as a personal story on why I decided that it's important for me to pursue equity and to pursue ownership in my practice, right, in my career. It's a little bit like what you were referring to, how when the partner asks you to bill, it doesn't feel that great, but when you're doing it for yourself, it feels really, really great. So I was motivated into ownership and to take my career into the ownership aspect based on Dave Chappelle. I don't know if you ever seen his stand-up special where he explained why he left Comedy Central.
I think I saw it, but I can't really remember.
Yeah, so he put it very ambiguously and cryptically in the beautiful way that Dave Chappelle does. And he relayed the whole thing to a book. It's called Pimp. And it's a autobiography of a 1920s pimp from Chicago. And the whole book is just about pimping, right? Ridiculous. But he drew it as an allegory on capitalism. And I'm not going to sit here and try to, just watch Dave Chappelle. He does Chappelle is a little bit of a better storyteller than I am. But essentially the idea is that Dave, he realized he was being pimped, right? Sure, Comedy Central was giving him $20 million and he had a show on TV, but he was being pimped. And that just lit a light bulb in my head. And I was thinking, I was like, what other profession do you sell your body, your attention, your efforts, and most importantly, your time, and you're billing that time by the hour. And then you only get to keep a small percentage of it.
Yeah.
Right? And professional services, including attorneys and prostitutes.
Yeah, there's some parallels.
Yeah. I'm not saying that lawyers are treated the same as streetwalkers, but if you break it down to the empiric
the financial dynamic is, is similar.
It's very similar. And, just same way the pimp goes, oh, sweetie, don't worry, I'll take care of you. We'll go buy you a pretty dress. The law firm is like, oh, here's some free lunches, and end of the year, we'll really take care of you. Don't worry, we'll take care of you.
Yeah.
Right.
Yeah. The promises kept being the goalposts removed, I guess you could say. Like even from the time when I started to when I had decided to leave, like when I started working there, the typical partnership track length was like by year 7 or 8, they were making people partner. It's like, okay, I can wrap my mind around that. And then it became more like 10 or 11 years and people still weren't making it. And it wasn't really clear why people were or were not making it. And then the people that did make it, like made less as junior partners at first than they did as senior associates. Cause there's like a buy-in, even if you're non-equity. And I was like, this stopped making sense a while ago.
Yeah, non-equity partner. I think it's
non-equity partner, but you're requiring buy-in does not make any sense to me.
Like what the hell? Well, this is one of the topics I want to touch on.
Buying into. Like,
yeah. Did you see the new lawsuit for non-equity partners?
I think I saw somebody at I can't remember the name of it. There was some employment partner that was suing the firm because the firm was treating her for some tax purpose as though she was like a partner in a partnership, but they weren't paying her like it.
Yeah, she was a non-equity partner.
Yeah. I have long thought that clients, this is just like a pet theory of mine, but at Kirkland, I think it's like every 7th year, once you hit that, they're going to start calling you partner. It's non-equity. And I think their justification is that it will help those attorneys in business development if they can say they're a partner. But if you're a client and you're paying partner level rates for a senior associate who's just being called a partner and they're not a partner in the partnership, like I think that that's misleading. I think you're misleading clients who are like, oh, who's the partner on the case? Well, it's like 7th year Rob. That's not the truth.
Yeah.
I think it's misleading.
Well, there's all kinds of misleading stuff in defense and big law, right? Like every year, the billing rate gets hiked up, and the dirty little secret is that it's all discounted.
Yeah. There's a lot of games that are played at that level for sure.
Yeah. This is my understanding of it, right? So obviously the real top players, right, like Cravath and Wachtell, they charge what they charge.
Yeah.
But some of the more smaller big law players, although they build their partners out at, actually, let's not even talk about partners. They build their associates out. It's ridiculous. Like a first-year associate would be billed out at, $700, $600 an hour, and then like a fifth-year associate is billing out at like $1,200.
Yeah.
Which is insane.
Yes.
Right. $1,200 an hour for a 28-year-old. That's McKinsey doesn't even do that.
Right. Yeah.
And but what they do is they'll advertise this price to raise the prestige of the firm, and then they will come in later and they'll say, oh, for you, client, you're special to us.
Yes.
We'll discount you 30%. Or we'll discount you. I mean, this is all hearsay. Obviously, this is closely guarded industry secrets.
Yeah.
But this, I mean, I don't know.
That is true. I mean, I can't speak for, I don't know what went on at the firm I was at in terms of like what I was actually billed at, or at least I very rarely saw that. But I know that what you're saying happens. There are firms where whatever the advertised rate is almost never actually charged to anybody.
Yeah. Well, I mean, this is all stuff that comes out through these kind of litigations, right? It comes out through discovery, comes out through allegations, and
fee disputes and billing disputes in a particular case. You'll see billing entries sometimes, and then those will get leaked to above the law, and that's how people like you and me find out about it usually.
Yeah. Well, anyways, I'm sure the audience is thrilled about all this billing talk. Yeah. This is what I think you can see from the way me and Robert respond. Like to lawyers, this stuff is exhilarating.
It's certainly interesting, especially if you're at a point in your career where you're deciding what you want to do or not do. Finance has become much more interesting a topic for sure.
Yeah, to bring it back a little bit earlier when I was saying some tasks feel more like work and less like work, I think it's personal. For me, I actually enjoy some of the admin stuff, like the working on the billing software and creating the platforms and really creating a synchronized process. But I never thought there'd be a day where I'm just really spending my Friday evenings messing through with my billing, with my QuickBooks.
Yeah. I mean, sometimes it's nice to see like, all right, run this report on how I'm doing this year comparing to last year. And then you can feel good going into the weekend. Like, all right, I'm on track to do X amount more. And like building the systems out was satisfying because it's like, I didn't know anything about how any of this stuff worked. As an associate, they don't teach you how to run a firm, obviously. And so there's a lot that you have to I mean, there's a ton of resources online that make it all easier if you're starting a solo shop, but I mean, it's
Almost too much.
There can be too much. Knowing who to listen to is important, I guess. But yeah, like getting all the systems up and running to the point where like, okay, all of this runs now. Like I have a system for everything I need is a pretty satisfying thing to get done.
Yeah. I don't know if you share this experience, but for me, I started out, well, I still am very much a lean operation, right? I'm trying to keep the overhead low. And when you're running a business, these B2B platforms, business-to-business platforms and vendors, I mean, everything costs money, right? And the discrepancy is so significant between one product versus the next product and how much it charges. And they're all SaaS. They're all software as a service, so they're all subscription based. And a lot of times you can't even figure out the price because they want to schedule a demo call with you first.
Yes, that always drives me crazy. Just tell me, like, give me a range on the website of like what this is going to cost me. Because I don't want to get on the phone. Exactly.
They're all, well, we really want to demo this stuff out to you.
Yeah.
I'm like,
I get it, but I don't like it.
Yeah, I hate that. I hate that. And, and I'll be really explicit with these guys. I'm like, look, I'm considering your product. I understand what it is. I don't know if the time is for me right now, but just please, like, just don't email me every day.
Yeah.
Like, don't text me. Like, don't call me every day.
Yeah.
I promise you I'll reach out. You guys are among one of three options.
Yeah. I think about that a lot, too, because I'll think, like, what person is responding to like the 7th email, but there must be it must work or else they wouldn't do it.
Unfortunately it does. As another side of business, I had to really get into the weeds with marketing. And I had to read all these white papers from Stanford Graduate School of Business, about marketing, and I have some friends that are marketing experts. And these touch points, they really are important. And I had to do it for my own practice with my own clients. And then that infuriates me more because I'm like, I understand why they're doing it. But I still don't like it. And anyways, I just try to integrate the best practices into my own work and make sure it is very explicit to the client. If you want to stop communication, just click here. I don't try to do that thing where people hide the unsubscribe button in white font on the email. Right. Actually, you're the perfect person to talk to about this.
that is one of the things I think about. Yeah.
Is that legal?
You need to, if we're talking about emails, it's really simple. You just have to provide a like reasonably conspicuous unsubscribe link. So like the Can Spam Act is almost never enforced. It's very rare because it's so easy to comply with. Like the joke is like it's called Can Spam because you can spam people. As long as you aren't putting misleading information in the subject line or misrepresenting who the email is from, and you have an unsubscribe link that people can find, then you basically can send unsolicited marketing emails. But yeah, like you need to let people unsubscribe or else you could have a problem.
I see. This act, the Can't Spam Act, is this a federal law or is this a state law?
Federal law.
Federal, okay. Yeah. I'm not aware of this.
Yeah, it's enforced by the FTC. Like I said, pretty rarely. There actually was a case last month that included a Can Spam claim, and it was just like business did not include unsubscribe link in email. Pretty straightforward. It's really not hard to comply with that law. That's why you don't see it come up very often.
I see. Okay. Is there a private right of action?
No.
Okay.
No,
That's why.
there are state laws that get more specific with emails, and again, it's one of those things that comes up so rarely. I can't remember if there's a private right of action for them. I'd have to check if California lets you, but email marketing is pretty easy to comply with.
I see.
Text messages gets a little bit more complicated, but and phone calls. But yeah, email, like, don't mislead people about what the email is about. Don't say it's from a business it's not from. Let people unsubscribe, and that's pretty much it.
I see. I see. Well, for the audience, can you actually forgive me? I got a little excited. Can you explain what a private right of action is? Because I think that's why.
Yeah. So, in a lot of people, it's a source of confusion because not every law that exists allows for every person to sue about that law being violated. So sometimes you'll hear from individuals who will say things like, you violated, this is against the FTC rules, I'm going to sue you. It's like, well, you don't get to do that because only the FTC can enforce the FTC Act. A private right of action refers to when a law explicitly says that individuals or businesses, or however they define a person, can bring a claim for violating the law. So if a law does not have a private right of action, what that means is only the government agency that's charged with enforcing it is able to enforce it. So the FTC Act is one that doesn't have it. CAN-SPAM Act is one that doesn't have it. So if somebody is going to enforce that law, it's going to be the agency that is authorized to enforce it.
I see. So to summarize, a private right of action is when a law gives the individual consumers the ability to bring suit themselves against the violation.
Correct. So like the TCPA is an example of law that does have a private right of action. The Telephone Consumer Protection Act, the purpose behind it is to help mitigate against spam calls and robocalls and texts and stuff like that. So it's not just the FTC or whatever government agency that can bring a TCPA claim. Individuals can too, and the plaintiff's bar loves the TCPA, or has for a long time, because when consumer laws provide for private rights of action, there's an opportunity to turn those claims into class actions, and that's where the real liability is if you're a defendant, and where the money is if you're a plaintiff's lawyer.
Yeah, well, that when there's a attorney fee provision too.
Yes, yeah, for sure.
Yeah, the private right of action provides the individual consumer with the ability to sue under the law, right?
Yeah.
It gives them standing.
Correct.
But then the attorney's fee, that's when it really enables the consumers to be able to bring these suits, because it lowers their barrier of entry.
Yeah.
And they can hire attorneys on contingency fee basis.
Right.
Right. For instance, like a lot of the laws I work with, the Fair Credit Reporting Act, and in California, things like the Rosenthal Act, they all have a very critical part, which is the fee shifting provision.
Yeah.
And it enables plaintiffs or the consumer, when you sue, if you are successful in proving the violation, then the defendant is on the hook for paying your lawyers.
Right.
And this really balances out the unequal power resources between the two sides, because you obviously don't have as much money as the bank to hire a lawyer.
Yeah.
But if you prove that they violated the law and they hurt you, they damaged you, and you're successful, then the bank will have to pay for your lawyer.
Yeah, and a lot of people do not realize that, like, contingent fee consumer lawsuits are something that exists. Like, a lot of the things that I tweet about, the majority of it probably is false advertising class actions. And people will say, well, this brand is so big, nobody has money for a lawyer to sue. Like, they have the money. And it's like, you don't pay anything. You only pay your attorney if you win, and the paying you do comes from whatever
the recovery
you were awarded in a settlement or a judgment. So there's no cost to you as the consumer to bringing one of these claims, and And so it's a misunderstanding people have that like, oh, there's nothing I can do if I'm ripped off by some big company because I can't afford a lawyer and they can afford the best ones. It's the class action mechanism is there, and that fee shifting in certain statutes is there to enable private policing of the marketplace and to balance that out, just like you said.
Yeah. And I'm really glad, Rob, that you have this perspective, because a lot of attorneys, with your background and your position representing businesses might not have this perspective, right?
Yeah, I mean that's why the mechanism exists. Whether it gets abused in some cases is up for debate, but
that's a different issue.
Yeah, the reason we have class actions is like, again, some of the cases I'll tweet about are like, let's take a bag of chips. It's like a $3 product. And the consumer has a claim that something on the packaging was misleading about what's in the bag. If there were no class actions, no one's ever going to sue, even if no attorney is going to invest the time over $3. Like, no chance. So the reason that we allow consumers to aggregate their claims and bring them on a class-wide basis is because that's the only way it makes financial sense to do that at all. So it's to help prevent against businesses ripping off a large number of people for a little bit of money.
Yeah, and this is a fairly complicated concept, and for me, this is one of the brilliant things about our legal system, about America, and why our economy is so great and why our system is so great. These legal mechanisms enables protection and justice. Right? Like if you go to some of the other countries without these legal mechanisms, people just accept that this is something that happens.
Yeah. I mean, of course it's not perfect, and the lawyers on both sides of the fence will find ways to exploit those imperfections, but it's a pretty damn good system, and I don't know that there's a better one out there. So
that's my argument. My argument. Because a lot of times, I'm from San Francisco, so I have a lot of diehard liberal friends, right? And they will just, they will just lay into me about, this is so bad, America, the system is so bad. I'm like, I'm not arguing things can be improved, right? Everything can always be improved.
Yeah. Like
Kobe Bryant is working out at the gym at 5 a.m. He's already pretty good at basketball.
Yeah.
But tell me a better one.
Yeah, it's the worst one except for all the others.
Yeah, exactly. Exactly. Okay, actually that touches on a really interesting point. I really want to talk to you about this. So we were talking about class actions and how it enables consumers to aggregate their claims and to hold these companies accountable for these seemingly small violations against each one person.
Yeah.
Right? And in the last 15 years, a very interesting development has happened, and unfortunately I found out less than a year ago that the people I work with were directly responsible for this, which is the class action waiver and arbitration agreements.
Yeah.
Can you talk a little bit about that?
Yes. So obviously businesses do not want to find themselves on the receiving end of a consumer class action. The liability can be business ending. So like, for example...
One second.
Yeah.
I just want to note that this is one of my favorite things. It's so seriously consequential for businesses that major class actions has to be reported on the company's 10Q for publicly traded companies as a potential liability.
Yeah. I mean, so you can imagine, like, I'll give an example. There's a law that basically prohibits businesses from advertising that an item is sold at a discount from some higher price unless the business actually offered that item for sale at the cross-through price for a certain amount of time. Mm-hmm. A very common marketing tactic is to show those like struck through prices. Was $100, now $50, limited time only, whatever. It's also a very popular category of consumer class action claim when businesses do not comply with the rules around how long you have to, the limits of how long you can offer that sale, the historical pricing of the item, and so forth. If we're talking about a piece of clothing that's maybe $50 and a business says, was 70, now 50. They never sold it for 70. They have a problem. Like we were talking about, on an individual basis, maybe the amount of damages we're talking about is like, maybe it's $50, maybe a little bit more. But if in the context of a class action, you can look at the exposure can be all of the items that were sold if they did that sort of tactic for all their products for going back like 3 or 4 years plus attorney's fees. So that could be all of the money your business has ever made plus attorney's fees. And I think it was 2 years now, there's a fashion retailer called Boohoo that was sued in several class actions that were consolidated over this exact issue. You're selling shirts and dresses and stuff. You said it was 70, now it's 50. You violated the law. And the amount they paid to settle that case was over $200 million.
Oh, wow.
So that's like, that's the amount that they thought, well, it's worth it to pay this so that we don't have to face what it might be if we took this to trial. And that's why I think the stats on the number of class action cases that actually make it to trial is something like 1% of them. Because if you're past, without getting into it, like if you're past class certification, you're taking like a bet the company kind of gamble if you're going to take that to trial. So the reason I went through all of that is like, well, why do businesses care so much about class actions in particular? It's because the liability is potentially catastrophic. So
back to arbitrations.
Right. So arbitration is, for people who might not know, it's like court, but it's not court. Basically, it's private court. The parties can agree to, look, instead of going to court and figuring this out, we will go before usually a retired judge, and we'll have a much more streamlined process. We agree that whatever this arbitrator recommends or decides, we will treat that as though a judge has issued a ruling, and we'll abide by that.
Binding arbitration.
Binding arbitration. One of the benefits, potentially for both sides, is that it's private. There's no public record that somebody can search to see if you were sued or what happened in it or anything like that. It usually takes less time. There's usually less discovery. It can be less expensive, but not always. Downsides are there's essentially no way to appeal what the arbitrator decided. So you can have an arbitrator that just gets the law wrong, and you might still be stuck with that, and there's no opportunity to have it reviewed. But one of the key features of arbitration for a business that wants to avoid class actions is that in transactions with consumers, like in a terms of service, when you check out on a website or something, you can present an arbitration clause that a court will enforce. And as part of that arbitration agreement, you can have the consumer agree that they will not bring their claim as part of any mass or class action, only in your individual capacity and not as part of any representative thing. So what that essentially means is, if, let's say, you only sell things online through your website, you can have all of your customers agree in a way that a court will enforce that none of you can aggregate your claims. If you want to sue us over the $3 bag of chips, it's going to be just you, and your damages are going to be what they are, just for you, and you can't aggregate them. So it's having an arbitration clause with the class waiver is a very important step for a business to consider implementing if class action liability is something that they're concerned about. We can get more into the topic of like how the plaintiffs' bar has responded to that and why some companies are just ditching that altogether. But one of the first things, it's really like the first line of defense against class action liability if you're an online retailer.
Mm-hmm. Mm-hmm. Yeah. And it's, see, again, I don't know if we want to get too into the weeds here because this is getting into legal nerd territory.
Yeah.
But yeah, I work with the people that developed the class action waiver that Rob is talking about. And you can tell this, just the spirit of how this developed was very interesting to me, right? I feel like this, initially when this was created, it was like, oh, this is brilliant. This is the end all be all of all this situation. We've eliminated this potential massive catastrophic consequence of aggregated class action, complex
Yeah.
litigation against these companies.
Yeah.
And then, yin and yang, sword always cuts on both sides. Plaintiffs bar attorneys, the brilliant ones, they figured out how to get past this with a new mechanism called mass arbitrations. And that's what you were talking about, right? How the companies are now dishing it.
Yeah. So the first example of this backfiring on a defendant, I can't remember if it's Postmates. I want to say it was Postmates. If it's not, apologies to Postmates. But part of the arbitration clause in class waiver has a history of courts sort of fine-tuning how you have to present that in a way that's not unconscionable. So most people, or many people, when they're told, like, hey, when you bought this, whatever it was online, you agreed to waive your right to go to court. Like, that's shocking to a lot of people. And understandably, it's like, what are you talking about? I bought, tickets to a movie theater and waived my right to a jury trial when I did that. Like, I didn't even know that happened. So over the years, courts have added or imposed requirements on how those terms are presented to the consumer. Like, you need to have notice of it, or at least constructive notice, and it needs to be, you can't just bury it somewhere in a long terms of service. You should call it out. It should be in bold or something. Like, make it more obvious to people that this is what you are agreeing to when you complete this transaction. And you should give people the right to opt out of that within a certain amount of time. One of the things that some courts will require, maybe all of them, I haven't looked at all of the law on it, but arbitration, there's fees associated with it. Like, both sides or sometimes the initiating party, depending on what forum you're in, has to pay thousands of dollars to start an arbitration. It's more expensive to start arbitration in terms of the fee schedule than it is to file a complaint. So to make that fair, some courts will say, like, all right, if you're going to require people to arbitrate, consumers, as part of a consumer transaction, then you need to cover the fees for them when they file, or somehow make the fee schedule more equitable. Because if everybody had to pay $10,000 to arbitrate, then that's not fair to people who might not have that or have a law firm who wants to do that. So in a lot of those clauses, the company will agree to pay the arbitration fees, at least at first. Smart plaintiffs' lawyers realized, like, okay, so if I can't get 1,000 people together and file one case, if I file 1,000 individual arbitrations, the fees this company is going to have to pay just to come to arbitration could be, like, let's say $10,000 times 1,000 people. That's a lot in fees. And what happened in the case that I'm thinking of was the arbitration fees alone for the number of individual arbitrations was, I want to say, like tens of millions of dollars. And the defendant was like, well, they're exploiting us. And the judge said, this is what you asked for. And so you made your bed, and now I'm going to make you lie in it. And so there's been a response to that in terms of, like, now the ADR forms, the arbitration forms will offer, like, mass arbitration rules to try to, like, stagger the number of individual cases. And it's like this arms race isn't the right term, but it's that kind of, like, balancing, and then the scales keep tipping. That was a long, deep dive into arbitration, I feel like. But a really just something that I'll share with you if you're interested afterwards. There was a case filed against Valve, the makers of the Steam gaming platform. And it was a mass arbitration scenario where thousands of individual arbitrations were filed. And Valve sued the plaintiff's firm in federal court for, I think, tortious interference and maybe abuse of process or something. Because somehow it leaked that the plaintiffs had sent a pitch deck to a third-party litigation financer explaining how to exploit mass arbitration filing fees. And they're like, this is how much it's going to cost them. If we get this number of Steam users, then they'll have to pay like, $500 million in arbitration fees or something like that. And it was a very interesting PowerPoint presentation that was attached that lays out exactly like, this is how you can have arbitration clauses backfire.
Yeah. No, that's I'm familiar, but yeah, I definitely want to talk more about that later. But this is a weird cat and mouse game, and it's really, really interesting. So, see, this stuff is, I love this stuff, right? And I want to try to keep it more entertaining and not so much in the legal nerd territory stuff, because I think we demonstrated that we could get in there.
Yeah.
But the whole reason I was bringing up arbitration is recently you were interviewed by the BBC twice, right? About a very interesting arbitration case that a lot of people have heard about.
Yeah, this was involving Disney. The short summary of the facts are this guy and his wife went to eat at a restaurant that's located on a Disney park. The wife had a severe food allergy that she made the staff aware of before she was served her meal.
She was a doctor.
She was a doctor. Somehow the meal that she was served included that allergen, and she had a severe reaction to it, and it ended up taking her life. And so her husband, on behalf of her estate, sued the restaurant and Disney as the owner of the property for wrongful death. And in response to that, Disney tried to argue that because the decedent's husband had signed up for a Disney Plus trial subscription 4 years prior, and because that Disney Plus, the Disney Plus terms included an arbitration clause, and then years later, because he again bought the tickets for both of them to go to the park, and the terms of service when he bought the tickets incorporated the Disney Plus terms by reference. Therefore, he has to arbitrate the claims that he's bringing on behalf of the estate of the person who died, who never used Disney Plus or anything. It's like the most attenuated argument to compel arbitration probably I've ever heard of. Would it have worked in a Florida court? Would a Florida judge maybe have bought that? Maybe. But the PR backlash was swift and severe.
And you contributed to that.
Yeah, like every outlet, every news outlet covered it. The tweets about it got like hundreds of millions of views. People were outraged. Many people already have a negative perception of Disney as this like behemoth company that's working evil in the world. I don't know exactly all the details of why, but they don't have great reputation in 2024 as it is. And this just was like a firestorm of bad, like, how can they do this? They should just pay up. This is so shocking and insulting. And I can understand how the lawyers at White and Case who represented Disney would, if you really wanted to arbitrate, you could think, yeah, this is a clever argument, and maybe if we're successful here, we can use that in other times when we're sued in Florida, and like maybe it'll be worth it to test the outer limits of how far our arbitration clause can reach. But I don't think that they anticipated the negative PR that would happen when they tried to do that. And as a result of that, they issued some statement that they said, after wereconsidering, we decided to abandon that theory. I think they read the opposition to that motion and thought, like, wow, we're really wrong. I don't think the argument would have worked at all anyway. But yeah, they tried to spin it as like, oh, now we're more compassionate, and of course you can have your day in court. But I think what really happened was somebody in-house at legal or at Disney's legal read the opposition, realized like, wait a minute, we argued what, and then saw all the news and then decided like, okay, no, we're gonna drop this. Yeah. But yeah, it was interesting that that example. I mean, first of all, it does sound shocking, and it sounds incredibly callous, I think, to a layperson to hear that Disney would try to get that claim out of court and into arbitration on that basis. but it also, like every once in a while, there will be a case that involves arbitration where people realize for the first time that when they do sort of everyday things like signing up to like watch a Star Wars movie on a Friday night, oh, I'm actually waiving my right to a trial for a whole range of things that might happen in the future as between me and this company. And when people learn that for the first time, a lot of times they're very upset by it.
Yeah. Yeah. I mean, you know, to bring it back a little bit, right, to provide a little more context, the right to a trial by your peers is one of the most fundamental things of our union.
Yes.
Right? Like the founding fathers were, you know, like freedom of speech and jury by your peers. Like those were like the key things, right? And then through brilliant legal work that's developed in the last, you know, 20, 30 years, we've evolved into this contractual binding arbitration paradigm where you sign a contract every time you do anything, right? And in the terms and agreements. And if you are interested in some more entertaining context, watch the South Park episode on that, right? On the iPad, right? And the human centipede. And now, unless you have a pretty good amount of legal knowledge and you immediately take action to opt out of these arbitration agreements, most oftentimes, you have agreed in contract to waive your right to a jury by peers.
Yeah.
Now, what Disney did was this lady doctor, she was eating at a restaurant in Disney World in Florida. She died. You know, it's a horrible what happened, but this kind of case happens all the time, right? But Disney, and they sued Disney for wrongful death. And Disney is saying, well, hey, your husband signed up for a Disney, you know, you guys tried to watch Star Wars 4 years ago, so now you can't go to a trial.
Right.
Right. I mean, the whole thing is just absurd.
Right. It feels innately wrong.
Yeah, it feels evil.
It does have that tinge to it, yeah.
Yeah.
But I'd say at a minimum, it was a massive PR miscalculation. That's the most charitable way to look at that situation, I think.
Yeah, I watched the press conference that you're referring to. I mean, when you have to issue a press conference about withdrawing a motion,
something went wrong.
Something is not going well.
Yeah.
It's, you know, this stuff keeps on developing and it's very, very interesting. And it's, you know, at the end of the day, you know, as attorneys, it's our job to represent our clients. But, you know, you never really know how these things, when you're a public-facing company of the size of Disney, you know, you never really know how these things are going to go. And there's so much risk management factors. And I mean, that's something that you deal with a lot in your work, right? Like you're advising companies on how these things could go, right?
Yeah, I mean, you try to give not just like an academic legal perspective on, you know, you can or can't do this, and here's what a court might say, but also try to give a little bit more insight into what are the repercussions of this outside of, you know, the courtroom or some arbitration or something like that. Like, how is this going to affect your business practically? Like, yes, maybe you could tell this consumer to get lost because your terms of service say no refunds or whatever. And sometimes that might be appropriate. Maybe, depending on the situation, like offering a partial refund if somebody is writing crazy emails about how they're going to sue you, maybe that's the better move because crazy people tend to make a lot more problems for businesses than people who actually start with a demand letter from a lawyer. Like crazy people who you think might just file a case and become a pro se headache, maybe you want to give that person a partial refund or something, even if legally you could rest on the contract. So I think it really is important to understand the context of like the business that your client is in and how things go, not just from a purely legal standpoint. And like, I mean, the Disney situation is just like a massive example of that. I mean, I can understand how that sort of thing can happen. A company of Disney's size probably is being sued, I don't know, a couple dozen times every single day for various things. And maybe not everybody is paying attention to every strategic move in every one of those cases, and somebody who should have been having their eyes on that strategy choice didn't, is probably how that went. But yeah, I mean, to summarize what I was saying is like, good counsel is not just advising you on what you can and can't do legally, but ideally some offering their perspective on what maybe they should do from a business standpoint too.
Yeah, it's complicated, right?
Yeah.
Like it's like if you have a son and he wants to wear he wants to wear a fedora to school. It's like, yeah, you can do that. But,
yeah. Nothing in the rules says.
It's not against the dress code, but maybe you should not.
Before.
Yeah. Yeah. Okay. So to touch back a little, let's bring it back a little bit more. Like, what kind of clients do you mostly work with through your practice?
Yeah, it's probably, I'd say 80% consumer brands and marketing agencies, and then maybe 20% individual talent and creators.
I see.
Yeah.
So you work a lot within this internet economy, social media influencers and e-commerce.
Yeah, businesses that make money by selling things online is the sort of like most zoomed out way to think about who I work with.
I see. I'm fascinated by this, right? Because we live in a day and age where social media engagement and eyeballs on you, attention is monetized, right? Like attention, I mean, I'm part of, like, I'm smack dab in the middle of the millennial generation, right? And I believe you're too, right? Mm-hmm. And we come from a world where we're the only generation that had a world before the internet, and we have awareness of it, and then we are also exist in a world that's very much post the internet.
Yeah.
And I remember the days when me and my buddies would sit around joking about how I would never take a selfie. You know, right. I would never take a selfie. That's so cringe. That's who would do that?
I thought I would never get an iPhone.
Yeah.
No buttons.
Yeah, it's insane.
It's not going to work.
But now, you know, social media followers and internet engagement really turns into dollars and cents for your clients, right? Well, for you and your clients.
Yeah, I mean, attention is. You could argue it's an attention economy, and that is what drives revenue for everybody to some extent. But yeah, I mean, the pace at which internet, the platforms that exist online, and the ways in which you can reach your target customer have evolved so rapidly, and marketers are really clever and are very quick to like ideate and then test what works and what doesn't, and figure out how to get people to click through and spend money. And then you have to square that with laws that have existed for a very long time and apply those existing laws to what marketers are up to, and then courts are like kind of in the middle of that process of first trying to understand what's even going on in terms of the tools and the strategies that marketers are using, and then applying those old, sometimes very old laws and new ones that come out to the landscape that's always changing. And that is what's interesting to me about the area of advertising law, especially with online stuff in particular. It's like the psychology of what advertising is and how it works and what actually gets people to buy is very interesting, where we as a society have decided like this way we're not going to tolerate, this is deceptive, this isn't, and then how courts sort of balance that and try to grapple with developments in tech that keep evolving at an increasing rate of evolution, and applying the laws to that is the most interesting area of the law to me. And so I'm grateful that I get to practice in it. Yeah,
well, it's very interesting. So are there developments in or regulations or laws in how businesses can advertise, using their social media, like their followers, like because you can buy fake followers now. You can I saw a case recently. Some guy, he created music using AI and then used bots to stream his music like 20 million times, and then Spotify sued him because he essentially scammed them out of millions of dollars.
Yeah.
Like, are there laws like that regulates this kind of stuff?
Yeah, and so the one that you identified with buying and selling fake followers, the FTC very recently issued a new rule or finalized a new rule that expressly covers or expressly prohibits some of the categories of activity that the FTC has long believed were deceptive and would bring enforcement actions about, but now they're like codified in a rule, which means that there's more tools available to the FTC in terms of penalties if a business violates it. So included in that new rule are prohibitions on buying and selling fake followers or other indicators of social media influence in connection with some commercial purpose. So if I just have like a personal account because I want to be cool and I buy 1 million followers, it's not a concern for the FTC. If I'm like a shoe brand and I buy 1 million followers, that is something that the FTC is concerned enough about in terms of the idea is that people will be more, they'll give more credit or they'll believe that a company has more influence or is more established or has a better reputation or whatever because they have these indicators of social media influence that are not real. Other things include paying for reviews without disclosing that they're paid for. You can incentivize customers to leave reviews. What you can't do is incentivize customers to leave reviews of a particular sentiment. So I cannot, even like disclosures aside, I cannot pay a customer like, hey, leave us 5 stars and get $10 off your next purchase. Cannot do that. I can't have a customer go leave a negative review on a competitor's site, even if they disclose that. Other things are like review suppression. If you're going to showcase reviews on your website, which some brands do, they don't want to just rely on Trustpilot or Amazon. They want to like house those on their website. So there are some tools for marketers out there that will automatically block reviews that are like under 3 stars from being entered into the system. The effect is that that website then only shows 3 to 5 star reviews. The new FTC rule expressly prohibits that. If you're going to showcase reviews and host them on your site, you cannot skim out negative ones and you can't suppress the negative ones. So you can't just show the 5-star ones first and then people have to dig to find them. You have to treat them equally. That doesn't mean that you have to host every review on your site. If someone's just not a customer or they're saying something that's lewd or defamatory or something like that, you don't have to host those. But you can't screen based on the sentiment of the review. There are a number of other things related to reviews that rule covers. Other new developments that the FTC has weighed in on have to do with the use of artificial intelligence and virtual influencers and things like that. So the FTC has made clear that all of the rules around disclosures and truth and the requirement of like truth in advertising for influencer marketing applies equally to a real person that a brand might pay to create some endorsement content. That applies equally if the influencer is AI generated. So that can become tricky. One of the issues that I see people ask about a lot lately has to do with AI generated content that looks like user generated content that is saying good things about a brand. So Whereas traditionally you might hire or pay some influencer to say like, I love these Nikes. I wear them every day. They're fantastic. That it takes time for the influencer or whoever it is to shoot the content. You have to pay them. You might have to ask them to redo it. There are tools now available to marketers that will allow you to just generate either a completely AI generated avatar to say those things about the shoes, or you can pay a creator some flat amount for the right to just generate anything with their, like it's a real person, but they never said those things or they never tried this product. The FTC's rule about that, about endorsements, or one of the rules about endorsements, is that any endorsement must reflect the endorser's honest beliefs and actual experiences with the product. So separate from AI, there was a case that the FTC brought a couple years ago, it might have been last year, 2 years ago at the most, against Google and iHeartMedia, which is a radio network, over...
We are available on iHeartMedia, by the way.
The issue there was Google wanted to have the radio hosts endorse and promote the new Pixel phone. It might have been the Pixel 4 at the time, or the 5 or something. But basically the host would say like, I love this phone. I use it every day. Here's how I use it. Turns out that the hosts were never given the phone. So they could not have been expressing their honest opinions or their actual experiences with the phone because they have no experience with it. And that violated that part of the FTC's rule about endorsements. So in the context of like AI influencers, if it's not a real person at all, then that necessarily is going to violate the FTC's rule about endorsements if you have that completely virtual person expressing some experience they have with the product. So if that AI avatar says, these are my new favorite shoes, it cannot be truthful because they can't have experiences. If instead they say like, these shoes are made with 100% leather or whatever, and they have this cushioning, and they're just describing the product, that can be okay because that's not an endorsement of it. But it's a similar issue if you have sort of licensed the right to use an influencer's likeness through one of those AI tools, and you type in some script that comes out like, this is my new favorite supplement. If that person has not only taken that supplement for long enough to see the results, and the script exactly matches their beliefs, then you have a problem. And that is one of the like recent developments in both the technology and the way marketers want to use the technology that the FTC has recently addressed.
I mean, this makes sense.
Right, it does. I mean, so much of the issues that I think about in my practice can get very technical and involve like parsing out what a regulation means. But at the end of the day, most of it comes down to, are you telling the truth to your customers or not?
Yeah, are you lying?
Yeah. And it reminds me of something that one of my friends said to another one of my friends. My friend had this idea of like, it was something like, I'm going to set up a website that's something like donatetogop.com and say, and make it look like a donation portal, and then in small print, like let people know that it's actually just going to me. And my friend said, like, do you think you're being clever?
That's just a scam.
Yeah, like, do you think you're being clever? If so, it's probably illegal. And I think about that a lot. It's like, because that's pretty true. Because a lot of people will say like, well, it's technically true, like what we're doing in this ad. It's like, okay, like, do you think you're getting away with something? Then maybe it's time to have counsel look at what you're doing.
Okay, if you think you're being clever and you think you're getting away with something,
that at least should trip something in your mind. Like, it's worth having this looked at to see if you're someone who cares about compliance, then that should alert you like, I see what we're doing here. Like, it's technically true what we're saying, but in reality, that's probably a sign that it's time to have a lawyer take a look at what you're doing.
That's true. That's true. And you bring up an interesting point. If you care about compliance,
yeah, right. And if you don't, fair enough. Like, my job is not really to just say like, this is what's legal and this isn't. Ultimately, the choice to as to whether to take on some legal risk is a business decision. But in order to make that decision, you have to know what the risk is. And that's what I see most of my job as being. Like, I need to understand a little bit about what the client's risk profile is, and then give them enough information so that then they can make that choice as to what level of compliance they want to be in for a given situation.
That makes sense. Now, what is the threshold for when a business that you've observed that they really start coming to you and seeking compliance in these? Because I mean, I imagine, obviously Disney, Nike, these major corporations, they need to be compliant because there's a lot of eyeballs. But to bring it back 360, right? Earlier when we were talking about the FTC new regulations on fake followers, I mean, that there's no private right of action, right? It's a FTC. So when does a business have to really start considering becoming compliant? Because if you're just a veneer tech, you're already, or you're just selling your stuff on Etsy, you're probably not too worried about compliance.
Yeah, in my experience, it varies a lot in terms of the stage at which a client becomes really concerned about compliance and how concerned they are. I have some clients who maybe they had previous business experience, or they had a bad litigation experience or something, and for their new business, even though it's small, they want to get everything right from the get-go. I have some clients that it's just in their personality that they'll say, like, I can't sleep if I feel like there's risk out there. I really want to have everything completely buttoned up. And that's fair enough. There are some clients that are doing very well. Maybe part of their financial success is because they are maybe not being 100% to the T compliant in every aspect of what they're doing. And growth might not have changed that for them, depending on what sector they're in. I don't want to get into specifics, obviously.
Yeah. Don't violate privilege.
Yeah, I mean, depending on the line of business you're in, you may be more comfortable with risk even at a bigger scale. So there's really not like, this is the point at which a client tends to become concerned, because it's such an individual decision for that particular client to make. But it's also, while it's generally true that the FTC is concerned with bigger players, it's not universally true, and they have gone after small businesses. But it's also not just the FTC that's a concern. Like, state AGs and attorneys general enforce virtually identical laws and rules to what the FTC does, and they will go after much smaller companies. I had one client that was not a large business by any stretch. I don't know if they were even at $1 million in annual revenue, and they're investigated by the Attorney General for the state version of the mail order rule. Like, you have to ship products by a certain amount of time, and if you don't, you have to send notices. And it was extremely stressful. Like, the owner was a young guy. He had not had any kind of litigation experience before. And he was surprised and at first very disoriented by the fact that he was being investigated by the government for his small business. So, clients will often ask, like, how much money do I need to make before I'm a target? And there's no real answer to that. It could be now, it could be once you're bigger. Like, generally bigger targets get more attention, but it's not necessarily true.
Yeah, it's hard to pin this stuff down, and you never really know. But I think generally it's just a good practice if you're a consumer-facing company to be pretty buttoned up, because I imagine that client became investigated after quite a few complaints were filed against him.
Yeah, and that's one of the ways that you can get on a regulator's radar, is by getting a significant number of the same kind of customer complaint on a platform like Trustpilot or the Better Business Bureau, and not responding to it. Because not only do we know that that's how a lot of cases get referred to regulators, but in many class action complaints, the plaintiffs' lawyers will use Trustpilot screenshots also, especially in the context of, like, businesses accused of violating the rules about canceling subscriptions. You'll see like sometimes 2 pages, like look at all these people who were upset that they couldn't cancel as like evidence or that, you know, people are complaining about this and they're being misled. So yeah, customer reviews, negative customer reviews, you should really pay attention to them, especially if you notice that you're getting a lot on the same issue.
That makes sense. That makes a lot of sense. Yeah, it's, you know, this stuff is just constantly developing, and that's the beauty of our economic system, right? There's always new ways to make money, and there's always a cat and mouse game. And just unfortunately, at the end of the day, it's the consumer who ends up paying the price a lot of times, and it's unfortunate. But you know, we're lucky that we do exist within an ecosystem that has regulators, that has you know, has attorneys on both sides, and you know, I think at the end of the day, what we have is the best version of it, right? Like compared to other systems, like where there are just outrageous, widespread violations and anti-consumer behavior. Yeah. Like at least here, to know that the government is stepping in and buying fake followers, I don't know, that brings a little piece to my heart.
Yeah, yeah. I mean, I'm not an expert on any other country's landscape of how regulations work, but I feel like we have like I said, not a perfect system, but certainly a working one.
Yeah.
And you know, the pendulum kind of goes back and forth depending on the administrations. Like, is it too consumer friendly such that it's anti-business, or is it the other way around? But I think overall, we do a pretty good job in this country of protecting the interests of business and the public.
Yeah, and I mean, we can even bring it down a smaller scale, right? Like you said with the state AGs. A good example is looking at how California regulates versus other states.
Yeah.
Right? And it's funny because, you know, if you listen to a lot of the rhetoric out there, they will say, you know, the socialist, Socialist Republic of California.
Yeah.
Because we have incredible amount of pro-consumer laws and heavy regulation. But, you know, there's also, I mean, compared to a place like Florida, does not.
Yeah.
Right? But also one place is like the crypto scam capital of the world. And the other place, not that we don't have our fair share, but, you know, maybe a little bit less.
Yeah. Yeah, it's interesting, and that is like, those are the 2 states that always get compared. Mm-hmm. I was talking with a plaintiff's consumer lawyer in Florida recently, and he's like, yeah, every time I learn about what you guys have in California, I'm just shocked. It's like, comparatively, we don't have laws in Florida. They basically don't exist, especially for things like employment. I mean, California is probably the toughest state from a regulatory perspective to do business in the whole country, and you know, that's generally good for the people, like the individuals who live here. But you know, do we overregulate on some things? I think that's fair to say.
Yeah.
But yeah, all of it's interesting, and even that dynamic changes over time. Like I said, depending on who's in the legislature and who's lobbying for what reason, and that's what keeps the practice interesting too, because I don't know what it's going to look like in a few years in terms of, you know, what laws are we going to pass, who's it's going to favor, how are plaintiffs' lawyers going to exploit them, and how is all that going to shake out? Yeah.
Yeah. Well, at the end of the day, you know, as observers, you know, and as people who are just interested in a topic, it's always fun to review, to study, and to, you know, to discuss. But anyways, thank you so much, Rob, for having a conversation with me today, and interesting as always. Thank you so much, and until the next time we talk to you, thanks for listening, and this is another episode of the Avocado Toast. Thank you.